Today I want to talk about the law of child protection, focusing on the recent UK Supreme Court decision in Re J Children. Child protection law is the means by which a local authority can remove children from their parents in order to protect those children from the harm caused by substandard care. It raises some very difficult issues and is rarely out of the news. If the state intervenes too readily, it could cause serious damage to the family lives of the parents and the children without an adequate basis for doing so. On the other hand, I need only mention the name of baby Peter Connolly to point out the possible consequences if the state fails to intervene quickly or effectively. The criteria for a care order, which allows a local authority to take a child into foster care without the consent of the child's parents, can be found in the Children Act 1989. One of those criteria is that the child is suffering or is likely to suffer significant harm. But unfortunately, some children are suffering or likely to suffer significant harm even if their parents or other carers provide perfect care. So in most cases, that significant harm has to be attributable or linked to the care or the likely care not being what it would be reasonable to expect a parent to give the child. In other words, the relevant care must fall short of an acceptable standard, whether deliberately or accidentally. Those apparently straightforward words, forming part of the threshold for state intervention, after which the child's best interests become paramount, had been considered numerous times by the House of Lords and its replacement, the Supreme Court, even before the recent decision in Re J. In interpreting the various parts of the threshold, the highest courts have flitted between interventionist and non-interventionist approaches. It has been established, for example, that a likelihood of harm need only be a real possibility of harm for the purposes of the threshold. In other words, it's not necessary to show that the future harm is more likely to happen than not to happen. However, the House of Lords has also said that the prediction of a real possibility of future harm must be based on facts proven on the balance of probabilities, which is the usual standard of proof in civil law cases. Mere suspicion that a child has been harmed in the past cannot form the basis of a likelihood of significant harm to that child or other children cared for by the same people in the future. On the attribution question, by contrast, the courts have been more willing to intervene. It must be shown that there is suffering or a likelihood of suffering significant harm attributable to one or more of the child's carers, based on facts relating to that child, or in the case of likelihood, another child cared for by all the same people. But once that's been demonstrated, it is not necessary to show which of the carers actually caused past harm. All the suspects are put into what's known as a pool of perpetrators if there's a real possibility that they caused the harm. But the threshold is met even though the precise cause of past harm hasn't been identified. Controversially, this means that a child could be removed from his parents even if it's possible that the child's previous injuries were caused by a childminder, and that the parents themselves are innocent. The previous cases, however, hadn't conclusively resolved a vital question. What if a parent has previously been placed in a pool of perpetrators in relation to the harm of one child, but has separated herself from the other people in the pool and started to look after different children, perhaps with a new partner? Does the possibility that the parent may have been responsible for proven harm to a child in the past provide enough of a basis to say that the threshold is met in relation to the other children she's now looking after? That was the issue with which the Supreme Court recently grappled. The background facts of Re J are pretty grim even by the standards of child protection cases. JJ and her partner SW had a child, TL. TL had a tragically short life. She died of asphyxiation at the age of 3 weeks and was found to have sustained many non-accidental injuries, including multiple rib fractures. JJ and SW then had a second child, S. Unsurprisingly, S was taken into care, even though the judge dealing with his case wasn't able to decide whether his sister TL's injuries had been caused by their mother, JJ, their father, SW, or both of them. S was in the care of both culprits and the threshold was met. That was not, however, the end of the story. JJ then separated from SW and moved from South Wales to the north of England. About 4 years after TL's death, JJ started a relationship with DJ. JJ moved in with him and his 2 children from a previous relationship. She later had another child with SW, and she and DJ lived together with the 3 children as a family. When it eventually found out what had happened in South Wales, Stockton-on-Tees Borough Council applied for a care order in respect of all 3 children. The issue the Supreme Court had to decide was whether JJ's inclusion in a pool of perpetrators in relation to TL could itself form the basis of a likelihood of significant harm to the 3 children she was now looking after in her new relationship. The court unanimously said that the answer was no. Lady Hale, with whom the other justices largely agreed, was conscious of the need for a balanced approach between intrusion and protection. But she emphasised that for the purposes of Article 8 of the European Convention on Human Rights, there has to be a pressing social need before state intervention can be justified. Lady Hale said that because of the doubt about whether SW or JJ had caused the injuries to TL, there was only a real possibility that JJ had caused them. Her ladyship held that to base the likelihood of future harm to the 3 other children on that real possibility would be inconsistent with previous cases requiring facts on which the likelihood of harm was based to be proved on the balance of probability. In her view, it made no difference that harm had definitely been caused to TL, or that the courts had taken a more flexible approach to the attribution question. However, she and 4 other members of the court didn't think that JJ's consignment to a pool of perpetrators should be ignored altogether. In their view, most clearly explained by Lord Hope, if the council had advanced other evidence, something it had chosen not to do in Re J, that evidence could be combined with JJ's presence in the pool to provide sufficient facts proven on the balance of probabilities. Lords Wilson and Sumption went further than Lady Hale and other members of the court, although not in a way that affected the result in the case. They were uncomfortable with the suggestion that JJ's presence in the pool of perpetrators would become valuable evidence when combined with other factors, even though it couldn't be used on its own. They therefore regarded it as something that should only invite further inquiry into the other circumstances of the case. Whichever view is correct, the Supreme Court did point out that few cases are so stark and simplistic that the only evidence on which the local authority's case is based will be a parent's inclusion in a previous pool of perpetrators. There will almost always be other provable facts ultimately giving rise to harm or a likelihood of harm. But evidence can be difficult to gather in the child protection context, and the law must surely be equipped to deal with the most extreme cases. While parents like JJ will now find it easier to make a new start in a new relationship where they've been merely suspected of harming children in the past, and their new partners are less vulnerable to having their children taken away, the Supreme Court's conclusion could produce some odd results. We've seen that S, a child being cared for by all the people in a pool of perpetrators, could be taken into care without much difficulty following the harm to his sister. But Re J seems to mean that if SW and JJ both formed new relationships and had children in those relationships, the threshold couldn't be based on the harm to TL alone in relation to either new household, even though it's clear that at least one of SW and JJ caused that harm to TL. At least the law is now clearer, and that's a positive thing in itself, even if local authorities will have to work harder in gathering evidence to protect some children. But the inherent tension between non-intervention and protection in this area of the law will remain, and social workers and judges will often be faced with extremely troubling decisions.